Today, we will discuss the so-called zero tax strategy and the benefits of relocating to Puerto Rico to reduce or even eliminate federal income taxes. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, as well as a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Puerto Rico offers a unique opportunity for individuals and businesses seeking to minimize their tax burdens through its well-known tax incentives, namely Acts 20, 22, and 60. These incentives are designed to attract investment and stimulate economic growth on the island. However, the complexity of these incentives requires a thorough understanding and careful planning. Engaging the services of a qualified attorney and CPA is crucial to navigate these intricate legal landscapes effectively. Act 20, also known as the Export Services Act, aims to promote the export of services from Puerto Rico to jurisdictions outside the island. This act provides eligible businesses with a tax rate as low as 4% on income derived from such services. Meanwhile, Act 22, the Individual Investors Act, targets individuals by offering a 100% tax exemption on all passive income, including interest, dividends, and capital gains. Act 60, that's 60, known as the Incentives Code, consolidates and modernizes these and other incentives, providing a comprehensive framework for tax benefits. While the potential for tax savings is significant, these acts carry with them stringent requirements and conditions. Misinterpretations or inadvertent oversights can lead to costly penalties and even disqualification in certain circumstances. Thus, it is imperative to consult with an experienced attorney and CPA who can provide tailored advice and ensure compliance with all legal stipulations. Determining eligibility for Puerto Rico's tax incentives under Acts 20, 22, and 60 involves several specific criteria, each with its own set of requirements. For businesses seeking benefits under Act 20, the primary condition is that the services provided must be exported outside of Puerto Rico. This means that the client base must be predominantly consistent of non-residents of Puerto Rico, and that the services must not compete with local businesses. For individual investors under Act 22, the requirements are distinct. Applicants must be bona fide residents of Puerto Rico. Why do I pause and emphasize this? Because simply moving on paper or purchasing a vacation home on the island will not count. This involves meeting the physical presence test, the tax home test, as I alluded to just a moment ago, and the closer connection test. Each of these tests requires careful documentation and consistent adherence to ensure compliance. The physical presence test, for instance, mandates that individuals must spend at least 183 days in Puerto Rico within a tax year. Act 60, which encompasses both Acts 20 and 22, also introduces additional criteria and compliance obligations. It is essential to understand these nuances and the implications of each act, as well as the interplay between them. The assistance of a knowledgeable professional is invaluable in navigating these complexities and ensuring that all criteria are consistently met. Establishing residency in Puerto Rico is a critical step for individuals seeking to benefit from Act 22 and Act 60. The process is multifaceted and requires meticulous planning and execution, not to mention excellent documentation. The first step involves physically relocating to Puerto Rico and establishing a primary residence. This includes securing a home, obtaining a Puerto Rican driver's license, and registering to vote on the island. Beyond physical relocation, individuals must also convincingly demonstrate a genuine intention to make Puerto Rico their permanent home. This involves severing significant ties with their previous domicile, such as selling or renting out property, closing bank accounts, and transferring memberships and affiliations to Puerto Rico-based entities. Documentation is key in proving residency. Individuals should maintain thorough records of travel, housing, and financial transactions. The complexities of these requirements underscores the importance of consulting with an attorney and CPA who can provide concrete and specific guidance on this topic and ensure that all necessary steps are taken to establish and maintain residency. For businesses aiming to qualify for Act 20, structuring the enterprise appropriately is crucial. The business must be organized and operated in a manner that aligns with the requirements of the Export Services Act. This typically involves incorporating or redomesticating the business in Puerto Rico and ensuring that the majority of its services are provided to clients outside the island. The business must also consistently demonstrate economic substance in Puerto Rico. What do we mean by that? This means that the business should have a physical office, employ local residents, and contribute to the Puerto Rican economy. The number of employees and the nature of the office space can vary depending upon the industry and the scale of operations, but the overarching goal is to establish a tangible physical presence on the island. Given the many complexities involved in structuring a business to meet these stringent requirements, it is strongly advisable to seek the expertise of an experienced attorney. These professionals can assist in developing and deploying a strategic plan, ensuring compliance with all legal requirements, and maximizing the utility of Act 20. Despite the potential advantages of Puerto Rico's tax incentives, several misconceptions persist. One common misunderstanding is the belief that simply relocating to Puerto Rico is sufficient to qualify for tax benefits. That is not true. In reality, the requirements are far more particular and stringent and involve a comprehensive commitment to establishing and maintaining residency and economic presence on the island. Another misconception is that these tax incentives are a form of tax evasion. That is not true either. On the contrary, Puerto Rico's tax incentives are legitimate and recognized by the Federal Internal Revenue Service. However, compliance with all statutory requirements is essential to avoid potential legal and tax quagmires. Additionally, some individuals and businesses underestimate the importance of maintaining meticulous records and documentation. Failure to do so can result in audits and the potential loss of tax benefits, as well as the imposition of significant penalties and interest. Engaging an experienced CPA can help dispel these misconceptions and provide clarity on the proper implementation of Puerto Rico's tax incentives. The implementation of a zero tax strategy leveraging Puerto Rico's tax incentives is, as I hope you understand by now, a complex endeavor that requires the expertise of both an attorney and CPA working together. These professionals play a crucial role in guiding individuals and businesses through the legal and financial intricacies of Acts 20, 22, and 60. An attorney can provide legal counsel on the requirements and ongoing obligations under each act, assist with the preparation and submission of necessary applications, and ensure general compliance with Puerto Rican laws. Meanwhile, a CPA can offer financial planning and tax advice, help structure business operations, and ensure accurate and timely filing of tax returns. The collaboration between an attorney and CPA is indispensable in developing a tailored strategy that maximizes tax benefits while minimizing risks. Their combined expertise ensures that all legal and financial aspects are, or at least should be, addressed, thereby providing peace of mind and confidence in the successful implementation of a zero tax strategy. In conclusion, while Puerto Rico's tax incentives under Acts 20, 22, and 60 offer significant opportunities for tax savings, the complexity and stringent requirements necessitate professional guidance. The potential pitfalls and misconceptions associated with these incentives further highlight the importance of consulting with an experienced professional beforehand. By engaging these professionals, individuals and businesses can navigate the intricate legal and financial landscapes with confidence, ensuring compliance and maximizing the benefits of Puerto Rico's tax incentives and overall quality of life. The strategic implementation of a zero tax strategy requires careful advanced planning, meticulous execution, and ongoing documentation, all of which are best achieved with expert assistance. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my other videos, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.